right, we're on the record. Hooray. Well, thank you for joining me, ladies. We have one other person, or is that three? Is that us? We're just going to chat here. But I'm going to introduce you. Thank you for joining Speaker Pro. My objective with Speaker Pro, with every single segment I have, I do this every Tuesday at 2 p.m., is to help people in the speaker industry better improve their platform and their presence. And there's all sorts of different little angles and pieces that we can talk about. And today I want to talk about the laws and the effects of not just speaker contracts, but coaching contracts, because I know a lot of speakers couple their business with coaching. So in a way, they're synonymous, but there's a lot of language that's important. There's a lot of provisions, I think, that are really important. So I can't wait to dig in with you. But I want to just introduce who you are. Nakia Gray is committed to helping each other, wave so we know which one you are.
That's me.
Helping others create their own economy through branding, marketing, and passionate entrepreneurship. I love that. As the CEO and founder of Nakia Gray Legal PC, a virtual law firm, Nakia enjoys helping creative entrepreneurs and artists establish a brand and build a profitable business by protecting and leveraging their creative work. And I am going to, in the messages, drop her web address in there so you can visit her website if you so desire. There it is. And Tamsen at the bottom, Tamsen Horton is changing the experience of law with innovation and practical insights of the legal impact of your business decisions. She enjoys bringing law to life and showing you how easy, accessible, understandable, and affordable it can be. And it's the VUJ website, right?
Yep, Vujade. It's fine.
Yep. I love that. I love that. So there is your website. So welcome to those entering the room. Please share it with a little birdie. I think this is really valuable information. And it's something that, frankly, I'm not sure many of us may think we need. But I have discovered as a coach and a speaker that without it, it can actually cause a problem. So for those of us that are speakers, we've signed a contract or two in our time. We've had organizations sign ours, but are we fully protecting ourselves? What are we missing, if anything? And as I mentioned earlier, even coaches have contracts. So in a word, these contracts are meant to protect the coach from being subject to litigation. And I personally know a few coaches who have been sued after a client claims that they didn't get what they were supposed to get out of that contract. And this is despite the fact that they signed a contract with language that the coach or speaker thought would protect them. So today, we're talking contracts. When do they protect us? When don't they protect us? And do we always need them? So good day to you, ladies. I want to start first with speaker contracts. As a keynote myself, I know that I have a contract for every organization to sign, and it basically says that they have to pay me. They have to pay me half of my honorarium before the engagement, and it even has details of what the talk is about, so I can deliver, and organizers can't go back later and say that I didn't meet that obligation.
Right.
It also protects me in case they cancel the event, so I still get paid, which I've had situations where that didn't pan out so well with the organizer, even though they signed that actual contract. Mm-hmm. So my contract does a lot of things. It doesn't insure me and it doesn't protect me, but Tamsen, I'm going to, protect me as far as insurance. Yeah. Can you start by sharing with us the basics of what should be in a speaker contract, what provisions, and what do we need in that contract the most?
You mentioned a couple of the biggies, payment terms is huge. What are you being paid to do? And even people think, well, I'm not getting paid. I don't have to worry about it. Mm-hmm. Free is still being paid. Like you are still exchanging your services for their event. So take money out of the picture. I tell clients, even when you're doing it for free, we protect you as if you were being paid $1 million, because really it's the free times that cause the most headache.
Oh,
because
wow.
You're really kind of dealing with, in those situations, your chances of running into people that have not been as exposed to it, don't have, I don't want to use the word amateur because that's the wrong word, but
newbie.
Yeah, newbie or rookie or whatever it is, that they get too caught up in the emotions of it and they don't nail it down. Whereas if you go, okay, I'm paying you $100,000, even if I'm not, you'd nail things down far better than if you're like, oh, I'll do it for free. Then you overlook things and then it turns into a disaster. But it's all the payment terms, how are you paid? When are you paid? Who's the legal entity responsible for paying you? a lot of times these events are 2 or 3 friends that put them on, could be. Mm-hmm. And then they don't, like you said, they don't get the registrations that they want. And suddenly they have to pay the place that they held the event, and they don't want to pay you. Well, then it's like, okay, well, which legal entity was responsible for paying you? The other stuff that really comes into play is, what counts as a pitch? Can you pitch? Can you get the photos? Yeah. Is there a photographer at the event? Can you get those photos, or are they going to charge you? Can you get a copy of the video to use for your speaker's reel? That kind of stuff is, again, it's not the typical contract boilerplate, but when you're dealing with speakers, it should be typical stuff.
Yeah. Nakia, do you want to have anything to add to that? Because I have a few questions, but if there's something, yeah.
Sure. And I would even add, a lot of times, like Tamsen said, we think when we're doing free that it's just free, but it doesn't have to be free. There are other things that you can get in terms of, definitely one of the things I try to negotiate is some type of pitch time or product table or something like that. Getting a list of the registrants. That's something, and you need to be protected in that your contract states that, because if that's not disclosed to the participants or the registrants, you want to be able to say that was on the host of the event and not you, because your contract says that you were permitted to receive the list of the registrants and to, and then even with pitching, does it need to be approved? How can you pitch? What can you pitch? I was a speaker at an event recently and earlier this year, and I was shocked that one of the panelists pitched her event that was pretty much exactly like the event we were speaking at. And I thought, oh my God, that is such bad taste. But if there was no contract that said she couldn't do that. So, that's the kind of thing you want to be careful of in terms of, and then you want to be specific. I hate saying that word, specific about the terms of the payment, because if there is a guarantee that you want to have in terms of the number of registrants, that kind of needs to be disclosed up front. So you can't have a contract that says we're going to pay you X to appear on this date. And then when you as a speaker have blocked that time off on your calendar, may have made travel arrangements, may have passed up another speaking engagement to be there. And then if they decide, oh, we didn't get enough registrants, and so we're not going to put it on, and just you're out of the no money that you were getting from the beginning. So we kind of need to think about, what happens if is there going to be a certain number? Is this contingent upon a certain number of registrations? That kind of thing. Those are things that I think are very important in terms of what you can negotiate, even if you are appearing and you're not receiving money per se, but other things that you can negotiate and that need to kind of be in writing, I think.
I actually have a provision in my contract, and for those of you, and then we've got a question from Summit Social. I started looking for my contracts online from other speakers, sat down with an attorney who happens to be my husband to make sure I was covered in every way that I could. One of the things that I had, and it didn't pan out for me, was there's actually language in there that says, even if an act of God stops this from happening, right? As you mentioned earlier, Nakia, I've taken the day, I've blocked the day. Right. I personally take half down, so you pay me within 30 days of the contract, so I get half of it, and then I receive the other half later. How can a speaker respond? Because in my situation, and this happened some time ago, despite the signature of that contract, they still didn't pay me. How does a speaker approach someone in that instance, even though they've signed a contract?
Well, I would say, first of all, Summit Social is exactly right in terms of the clause, in terms of the act of God. And I would say that they are still obligated to, under that contract. Now, the thing about contracts is that not everybody abides by them. Not everyone fully understands them, unfortunately. And so I would say having your attorney send what we call a demand letter, a demand for payment that says, under the terms of this contract, Hurricane so-and-so came in and wiped things out, but that didn't stop me from having set this aside and so forth. And so you are obligated to pay. And some people will and some people won't. And then you have to decide whether the amount is, whether it makes sense for you to go to court, because you absolutely have a valid contract. And if you have all of the proper clauses, which I'm sure your husband made sure that you did in terms of the venue and where disputes are, how disputes are to be resolved, where they are to be resolved, then you would have a claim to go to court. And, again, you got to decide if we're talking about, a couple $1,000s, is it worth it for you to spend a couple thousand to possibly get a couple thousand? But if we're talking about $50,000, that's a different conversation. So you have to decide what makes sense for you financially to pursue it.
How effective is a demand letter? And then I promise I'm getting to your question.
I think that
depends on the recipient.
It does depend on the recipient. You're right. But I would say, my demand letters are pretty effective. I think, a lot of times people, I just like to look at the world with rose-colored glasses a lot of times. And I think that a lot of times people don't really know. And so they're not purposely not abiding by the contract. It takes the letter from the lawyer that says, hey, you still do owe this money or such and such. And so I like to think that most people are pretty good Samaritans, and they think, oh, well, I didn't think that I still owed, but if I do, I am going to fulfill that obligation. Most people, I think, are that way. Would you agree, Tamsen? I think that most people don't set out to dupe you in a contract. I think that they just didn't know. And it takes the lawyer, or it takes them getting the letter from the lawyer, taking it to their lawyer, and the lawyer saying, you kind of are wrong here. You need to pay.
Yeah. And what Nakia said is right. It's what I always tell clients is there's the purity of the law, and you can be as right can be in the law. And then there's the practical play out. And now the other layer that we all have that is a factor is the social implications. Let's say you do this and you send letters. What I always tell clients is we're going to do this professionally and respectfully. Yeah. It's got the legal teeth behind it, but you're not posting this on social media. You're not going to go off, crazy, because you don't want the social backlash of someone then taking in after you as the event was awful. It was out of my control. And now here's this horrible, awful person demanding money from me. Right. So it's always tell people, it's like those three pieces: legal, which you got to make sure you're in the right on the legal; practical, if it's going to cost you $2,000 with an attorney to fight over a $200 speaking fee. Yeah. And then the social part, make sure you're just being smart about, because I've always seen it. There's an interplay amongst those things.
Definitely.
Great point. Summit Social asks, what is a typical outline of a speaker's contract? What terms should be included for the host? Anything you want to offer for that, either one of you, to begin with? I know what I could offer because I have contracts, but you're the pros here. You're the attorneys.
I can start. I think definitely you want to start with the basic terms in terms of the event, where it's going to be, who's paying for what's included, the topic. The topic is really important because that's an easy way that I've seen where there's been some dispute in the contract is that, the host thought that you were going to speak about one thing and you thought you were speaking about something else. So definitely those are the basics. You definitely want to have those things. And then, I like to say as lawyers, we're always thinking of where can things go wrong? Well, what if? And so I do the what if game, right? Do you do this, Tamsen? We play the what if game. Okay.
Worst case scenario at all times.
It's all
worst case scenario all times.
Yes. Worst case scenario at all times. And so that's what helps us frame get the framework of the contract. What if I can't go? What if I get sick? What if not enough people register? What if there's a hurricane? What if, all these different things. And so then you have to play that out. Can I send someone else? Maybe I, or if we don't have enough registrants, can we cancel by this certain date? What are the terms of the payment? How much is going to be paid? And again, I can't stress this enough when we're talking about free, for those speakers that are just starting out and they're trying to build, what can you get that's not money? and how can we negotiate that as best we can? Can you get a table? Can you sell things? Can you get some free promotion or social media advertising beforehand? Can you, different things like that, or posting to their, after the event, can we get some live tweeting? Can we get something afterwards? As much as you can negotiate on in terms of the payment, and how disputes are going to be resolved. That's huge. And I can't believe how many contracts I read that never, address, well, what happens if something goes wrong. The old digital age that we live in, we have the ability to communicate with one another. I mean, just the three of us here, we've got 3 different jurisdictions represented on this. And so if something goes wrong, where do I sue you? Do I sue you here in DC where I am? Do I sue you in Michigan?
Wow.
Do I sue you in New York? That's huge. That's a huge thing that definitely needs to be in there. Let's think.
The events so rarely put it in there.
Oh, and the pregnancy.
Like
yes.
these people that live in, like, let's say you live in Florida, but you decide to hold this retreat in California, and you don't specify. Okay, well, the person is from North Dakota. Let's say they sue you in North Dakota. Guess what?
Yeah.
You're defending yourself in North Dakota.
Mm-hmm.
Like, yeah, I'm with you, Nakia. They rarely say, hey, we're going to settle this in my home state because I don't want to leave.
Yes. I am so glad that you brought up the pregnancy clause. I think you should definitely talk about the pregnancy clause and virtual appearance clause, because sometimes these events are booked a year out.
Oh, yeah.
And someone may not be pregnant right now at the time that they commit to it. And
that is brilliant.
That they'll be on bed rest and they can't travel. And so is there a virtual appearance clause? I'll let you cover that.
Yeah, that's where, like I said, you're always thinking about worst case scenario. And I will tell you, I have yet to run across a male attorney that thought to include a pregnancy clause. Like, you go to an event and we're talking about different things, and I'm like, okay, but that's a reality. I mean, you can see me right now. I got a 29-week belly right here. But I had clients that we knew they were planning on being pregnant. And like Nakia said, it's a year out. Some of these things, I mean, they're not calling you the week before typically,
right.
But it's thinking through those life events and putting it into place that, okay, let's say, your husband is in a car accident the day before, or your child, I slammed my son's hand in the door Sunday afternoon, right as I was launching a program. Well, what if I was supposed to fly out the next day? Including those, okay, here's my life events. And then how could I handle that so that you now have a virtual element, thinking through, is there a way to accomplish this without a total, I can't be there.
That brings up,
I had one client.
I'm sorry, hold that thought, because I love that you had one client. Should that contract or that provision say something along the lines that the host or the event should have a backup plan?
Absolutely. Yes. Oh, absolutely. And that's where you just have people, you're obviously not planning for it to happen. But as I always tell people, if you plan for the worst case, then anything other than that is icing on the cake. But you still know I have an action plan for worst case.
Right.
Someone's on bed rest at 20 weeks. Well, really, you're going to, you don't want it to turn into a suing kind of a thing.
Right.
Where you're like, okay, let's just think through if there's a life event. And here's examples of, I always tend to put some examples in there, but then, use great lawyer language, including but not limited to.
Yes, our favorite.
You're always covering yourself, but that you want them to be thinking of, oh, yeah, I guess we should have a backup plan. I guess we should have a contingency, because again, it's going to make the whole thing go smoothly for everyone, even if there is a disaster and something goes wrong.
Mm-hmm. Summit, thank you for spending time with us. And I think we answered this, but I'll throw it out there. They ask, if you've never had a speaking gig yet, but you want to start, should you still have contracts even for Rotary, Kiwanis, chambers, and so on? Yeah.
Yes.
That's what I had said too. Yeah.
Yes.
I think the beautiful thing is, and I want to throw this in here, is I've had events where I have not gotten paid but negotiated, whether it be airfare or a hotel room or a vendor table, and I make sure it's very clear in there. But last year I was brought in by a college, and they couldn't pay me the full fee. They said, we can only give you $1,500, and it was just down the road. It was like 2 hours down the road. I asked for $2,000. So what I actually negotiated, we were talking negotiation, and I think that's a huge part of these contracts,
Huge.
is I said, I'll take your $1,500, but here's what I would like. I would like you to physically mail 3 letters of references to organizations that you know could use me, and CC me on those letters. I also want you to make me the keynote for this very same event next year at $2,000. And there was something else I had thrown in there. But I made sure, even though I didn't want that to be discussion, I wanted it to be actually in my contract. So I had addendums so they could do that. And sure enough, they're bringing me back next year. And they just mailed me part of that payment already so I could secure that spot. So I think it's extremely valuable to have every little piece in writing. I was an MC at an event, didn't get a dime or any of it in writing. They said, we'll pay you $300. I said, all right. Can you add to that through your social media channels, market my business? They said yes. They never did a thing. They never marketed me once. I wasn't even on their banners or the screens or anything. My logo was nowhere, and there's nothing I could do about it.
Well, there's one thing that you brought up that brought me to another thing that I would definitely include. And that is, and I always do this, confidentiality and non-disclosure clause in those contracts, because let's use your example with the school. We don't necessarily want those 3 references the letters that they sent. We don't want them to know that the school did that at your request. So it's not it's not any of their business that was part of your deal. So the school cannot disclose the terms of their contract with you with those 3 references, or with anyone else for that matter, because maybe there's if Oprah calls me, and wants me to speak, I may totally do that for free. But I don't want everyone to know that I did that for free. So Oprah can't go to say, oh, I know a free lawyer who you could get to come speak at your event called Nakia Gray. So I want the terms of that arrangement to remain confidential, and that even Oprah can't disclose the terms of our agreement. So that's very important, I think, because we may do things differently for each person that we're presented to speak. The way we negotiate may be different, and we don't necessarily want that to be public information.
Yeah, that's brilliant. That's something I didn't think about. And that's a concern for a lot of speakers, because, we may leverage this particular fee. But if another school down the road is going to pay me $5,000 and I negotiated $2,000, they don't need to know that. That's brilliant. Thank you for that.
Exactly.
Yeah, that's huge. Summit says, I always recommend. Oh no, that was Tamsen. She answered Summit. So for free gigs, ask for marketing, merch table, lodging, travel, anything. Summit, I ask for all of it. I have gotten free vendor tables. I've gotten an honorarium. Like if they can't pay me a fee, I've gotten an honorarium for $100 or $200 that I've negotiated, and a free vendor table. And I've been in the conference room at these events, and another speaker is complaining about the fee they had to pay for the table. And I'm thinking, oh my God, I didn't pay a dime. So don't be afraid to negotiate, because these conferences, these organizations are conditioned to this. They're used to this. So yeah, absolutely. Is there?
And it's like you never know what they have in their arsenal of. Yeah, the price looks like this to the outside world, but really, okay, we can throw that in and it's no big deal. I mean, I do it with leasing a new car. It's like, okay, yeah, you can't come down anymore on the payment, but I want 6 months of oil change coupons. Okay, that's pennies to you, and you charge me hundreds of dollars.
Yep.
So it's a win for me, and it's pennies for them. But you have to know your why. If you're like, oh, I want this free vendor table, but you have nothing to put on the table, then don't negotiate for the vendor table.
Right.
Negotiate for something that adds to your why you're putting the time in.
Yes.
Because there's stuff that the table might not cost that, really cost them anything, or they can write it off on another part. So ask Ask for the moon.
Ask for the moon. And even to answer Summit Social, even, I've looked at not just this event, maybe this one event is their smaller event that leads up to their huge retreat, later this year. So what can I get on that one?
Amen,
Think about that as well. Look at everything that they're doing.
Mm-hmm.
I leverage that. And that's what I did with the college is don't be afraid to say, well, what's down the road? If you can't do this for me here, can you do it for me down the road? One of the points that I wanted to make regarding the big why, when I ask for those 3 letters of recommendation, and this may serve you, Summit, and oh, hey, Revel, welcome. I ask for these letters and I ask them to be in hard copy. I make sure that they, I don't want them just to send them to a department at a college or to a no name or in general to an organization. I want the name and the contact information. And I always ask, and it's in my contract, that they send those letters within 14 days of my event. Because then when I get the hard copy, and I make it very clear it's not email, I can follow up with those organizations. So that to me, my why is because I want more of these particular organizations that utilize someone like me. So my why is it serves me. It serves me to have that letter in front of 3 people. It serves me to pick up the phone and call them. So very cool.
Absolutely.
So we're a half hour in talking about speaker contracts. This might be a good time to shift into coaching contracts. And the reason I wanted to include this is because I personally have never been affected, thank God. And I do have a contract in place, and I make sure that in my contract, and I'm not insured either, so it's something, I don't know if you can speak to this, ladies. I did talk to my insurance agent, and we talked about actually adding that. But in my contract, it basically says, I'm not responsible for your outcome. And it more or less says, I can't think of the language now, I should have printed it out. My point is, my coach, who's he knows his stuff, he's out there, he's a high-end coach, he has faced litigation and had to actually pay out because the particular person that was suing, their client at the time, said, I didn't learn anything from you and I didn't make any money.
Right.
How can coaches best protect themselves? What kind of language or stipulation should they have in those contracts to avoid someone coming back saying, you didn't do your job?
Well, I would say definitely, I've drafted lots of coaching contracts, and I always have all of the language about, what the coach's responsibilities are, what they're providing, that there's no guarantee. And not just leaving it at the coach's responsibility, but the client's responsibility. You got to show up. You got to do the work. You got to do these other things. But definitely having disclaimers that say there's no guarantee, there's no outcome. This is not the advice that is given is not to replace that of a lawyer, doctor, psychiatrist, everything that you can think of. It doesn't mean that you shouldn't still talk to your doctor or still talk to your tax advisor, having those kinds of disclaimers in there. And that, that they are assuming, again, it's all about managing expectations. And that's the theme that I always say in every contract. Let's manage the expectations. And if we do a good job at managing the expectations, that reduces the chances of there being some dispute later on, because we're very clear. And in my contracts, it specifically says coach's responsibilities, client responsibilities. Mm-hmm. So everyone knows what they're supposed to do. We play the what if game. If your program is 6 sessions, what happens if I miss one? Do I get to make it up? Is it lost? Let's be very specific about what's the exit strategy. If sometimes even with the best intentions, it's just not working out for whatever reason. 2 people just don't hit it off. Can the client get out? Can the coach get out? Sometimes the coach is like, this is way more than I bargained for, and this is not working. And for any coach, you don't want someone on your roster who's not going to be a success story for you, because that defeats the purpose of you coaching. Mm-hmm. So, having the exit strategy, what happens if we don't like this? And I think that, if you have those things in there, same with payments. I know a lot of coaches do payment arrangements and flexible payment options. What happens if I don't pay? What happens if my automatic recurring charge is declined? How many days do I get to get that corrected before you can just cancel it? So just playing through all of that. I like to be very specific about, what if something goes, the what if game? What if something goes wrong? What happens if they don't pay?
Mm-hmm. I think they're extremely important, the contracts are, but I think there's some coaches out there that don't consider it. What kind of, I dare say, use the word trouble?
Over 90%, I would say, don't consider it until there is
a problem,
an crisis moment. Exactly. And both, Nakia and I both, we've much prefer the preventative aspect.
Mm-hmm.
The reality is most people don't listen until you're like, okay, you're now in crisis.
Right.
Suddenly now it matters. And you're like, okay, but it could have been so much easier a month ago.
And more affordable, I imagine.
Exactly. Oh my goodness. Yes.
Can you share, and of course I recognize you can't share, but can you share a story? Because I would like people to understand what can happen if they don't put these safeguards into place. Can you share an example of a past client you may have had that faced this kind of litigation and what that looked like?
Sure. I have several. So I have one client who she hired this coach, and there was no contract at all, no contract, and it was a pretty significant amount of money that I personally would never spend without a contract. And there was a true miscommunication, I believe. I don't believe that this particular coach meant harm. I think that my client thought that she was getting one-on-one coaching when in fact she wasn't. She was getting a group coaching program. Mm-hmm. And she was very frustrated because she wanted one-on-one coaching, and she didn't realize that she had to actually go watch the modules that were pre-recorded, and that was the extent. There was no one-on-one time. And so and she wanted her money back. And of course I said to her, okay, well, send me the contract. Oh, there is no contract. Okay. So I sent a letter to this coach, and the coach couldn't believe that she didn't understand. Well, I talked to her. She knew that I never said that it was, and it's like, but there was no contract. And so the coach, fortunately, was very well known and did not want, as Tamsen talked about, the social backlash that would have happened possibly. And even though she had a no refund policy, she had not disclosed that. So she made good on that, and we were able to work it out. But that's one of those things where, not having a contract is just not a smart idea, because even though, with the best of intentions, she thought that she had communicated to this woman that this was a group program. And somehow my client did not get that at all. She honestly felt like, I paid all this money. There wasn't even a paper trail. She gave her credit card over the phone. There wasn't even a paper trail in the credit card. And I'm talking, 5 digits, over $10,000 coaching.
Wow. Tamsen, do you have anything to add to that story, or a story that's similar? Because my objective here is not to slam people who have made the mistake. My objective is to make sure that we don't make them.
Yeah. I am fortunate enough that the clients I have that are in these situations are calling me before they're signing things or when they're thinking about doing things. But I had one who was in the midst of signing, again, a 5-figure relationship deal. And I got a hold of, they sent me a copy, and I looked at it and I'm like, you're not signing this. There's no way we're signing this thing. But there was no exit strategy. There were no expectations. Things like, I'll help, I help you do, marketing. I'm like, what exactly is marketing to you? Because ask 10 people, marketing means 10 different things. I'll grow your business. Specifically, how are we growing this business?
Yes.
And those are things like I tell people all the time, I came from the corporate world. I had no intention of being a lawyer whatsoever. What drove me nuts was the lawyer saying, well, we're not going to sign this because it says the word reasonable. Okay, now I know that's one of my favorite words ever. But at the same time, it's like, you've got to, especially with coaching contracts, get specific. What does grow your business mean? And coaching to me is like this nebulous thing, you know? Provide examples in the form of an addendum, like especially for established coaches. Here's an example of the coaching program. Here's an example of, you know, whatever, the techniques that are used or the processes that are used. Again, you have language in there that's not like, yes, I'm going to exactly get this. It's not like you're going to buy a physical thing off a shelf, but it definitely helps avoid the litigation part and the people that are upset when you can say, well, here was a list of what I told you I'd provide you that provides that framework. But no, we've avoided the litigation. You know, one, I'm not a litigator, so I would pass it off to someone else anyhow if it got to that point. But the reason you can avoid it is on paper it says you owe money, but you have the solid drafting behind it that says, no, here's the specifics. Here's how it is. Exit strategies. Earnings disclaimers are huge right now. And those are required by law. Like those are Federal Trade Commission things. You know, all these people of, I'll teach you how to make 6 figures in 6 weeks. And they don't have earnings disclaimers. You're like, you are in so much trouble.
Can you talk a little bit about that? Expand on that a little bit.
Earnings disclaimers?
Yeah.
Yeah. You have to have in there, one, you should have it on your website at all times. It should live there when, especially if you are someone that promotes from the coaching aspect, like, again, 6 figures in 6, and I'm being extreme, I know, but there's so many of these.
I've seen them. 6 figures in 6 months.
Yeah. And you're like, your results, you know, all the language that basically says my headline means nothing. Like I used it for marketing purposes, but here's all the reasons why you can't hold me to any of that.
Wow.
I can't guarantee that you're going to make money. I can't, and once one of you starts talking, I'll pull up I don't remember the case offhand that the FTC requires that it came out of, but you're required to have it on there. There's a transparency element. Basically, truth in advertising is what it comes down to. But that moves you out of typical contract state law and moves you into federal law. Like the Federal Trade Commission is different than Michigan, you know, you broke a Michigan law type of a deal, like a contract thing. So it ups the ante. But that's where, when you're coaching, you have to know this is what I'm doing and talk with someone that can hash it out. And I tell clients when they're trying to decide really to which coach to work with, like if your coach isn't using legal contracts, that means they don't value their business.
Yeah, I love that you said that. That's great.
Yes.
Find a new coach.
Yes.
I love that you said that. That is fantastic.
Well, they didn't send me anything. Okay, then ask for it.
Right.
Oh, they said they don't have one. Find a new coach. I don't care who the person is. I don't care what their marketing page looks like.
Right.
They're not protecting themselves, so they're not going to protect you. I'm not paying money to help me get better when you're not even paying money to help yourself.
Right. Right.
I love that you said that.
Go
ahead. I just wanted to say you said that, and I had this huge aha moment because one of the greatest struggles we have, I think, as entrepreneurs is valuing who we are. And this all goes back to, and I'm not saying that coaching is such a unique industry because, as we've already discussed, how do you know that the person you're getting is going to provide the service that you desire and is very clear that you're going to get what you need? You know, I get the question all the time, should I have a coaching certification? Personally, my coach didn't. He just was killer at sales and he knows what he's doing. But as you mentioned, Tamsen, my results were much different than other people. I generate it in a way some people won't be able to. So I'm blown away by this whole disclaimer thing, but I absolutely love, and I hope the world hears this because it's interesting to me. I thought this would be really a stronger point of interest with this blab. I hope the world hears, and those that are in here, if you're signing up or you plan on getting involved with a coach and they don't have a contract, please back up. Please back up and talk to Nakia, talk to Tamsen, reconsider, do your homework and reconsider. I'm sorry, I had to throw that in there. Back to you, ladies.
The one
You're
thing
exactly right.
Yeah, it's absolutely right. One thing we didn't touch on that I just thought about in listening to Tamsen in terms of something that we want to have if you're a coach in your agreement is intellectual property. Mm-hmm. We have to be sure to let people know that they can't download your program and resell it or give it to their friends, or you want to make sure that you are protecting your intellectual property and you're letting them know that everything in this course is protected by your copyright and by trademark and are your trademarks, and they can't just use those things. And I know it sounds basic and it sounds like something that should go without saying, but I had another case where someone, and the sweet lady, good intentions mean nothing in the legal world. Okay. So in the world of intellectual property, the fact that you didn't know or you didn't mean to steal means nothing. Okay. But I had a lady who literally took someone's course and then recreated the exact course using the exact paperwork, same everything. And she actually admitted she thought it was okay. She said, I took this course so that I could get information for my course. She honestly believed that she could do that.
And there's so many coaches that don't understand their IP. Mark Getty has the best quote, and he says, intellectual property is the oil of the 21st century. Okay, just think about countries that are sitting on oil. Okay, right. They protect to the nth degree, and yet coaches who come up with all this stuff that they're known for, whatever, one, they don't use contracts. Huge red flag in my book. But then two, they don't explicitly say you can't enroll and regurgitate.
Yes.
You can't.
You can't.
And if you do, I will deal with you. Like they don't. And then they get upset and then you run into a whole other monster of issues. But the protecting your IP, Nakia, it's huge. That's your asset. That's really why people are paying you.
Exactly. And this is the we're in the information age. And that's how we all are making our living. And so, I say to my clients, your intellectual property is your real estate. I mean, essentially, if you're selling information products, which coaching is an information product, then you've got to protect that. And sometimes protecting that means just telling people, I'm not going to tolerate you using my stuff.
So do you find when you're working on these contracts with people that you have to impress that upon these coaches because it's something they don't think about, or do you find that they bring it up because they don't want it to happen? Thanks, Dan.
I would say
I get the, I never thought of that.
Right.
Mm-hmm. I get that all the time because you start saying, well, what about this and what about that? Which it should be. You didn't go to law school. I wouldn't have thought about any of it before I went to law school.
Exactly.
And I never would have thought about that. Oh, yeah, we're putting that in there.
Yeah. So, ladies, here I am a speaker. I have a contract. After this particular blab, I know that I'd want to reach out to one of you to help reconstruct it to make sure I'm safe. What can you tell coaches and speakers that are out there? Because I know what some of the resistance is. One, they don't have the understanding that it should be done. Or two, if they do have the understanding, they don't want to invest in protecting themselves. Can you give us a general idea of what it would look like if they were to sit down with one of you to have a contract created? And I recognize it's broad, and there's a lot of different facets that are part of that.
Right. I typically would like to have a consultation with them to figure out exactly what they're offering. Again, it's our job to think of all the things that you didn't think about, and then to get a contract drafted. What some people do is they already have a contract and they'd like me to review it and give them, my take on whether there's something missing.
Mm-hmm.
And I definitely welcome the opportunity to do that, and I do that a lot because sometimes people have received contracts from other people, and they take a little bit from this person, a little bit here, a little bit from Google, a little bit there, and they want to just know whether or not. I have not seen one yet that has everything that I think that it should have, but I do recognize that different budgets require different things. And I say to people, in fact, just today, I said to someone, it's okay to start out with the contract that you have it reviewed by me, get a few more clients under your belt, and then come up, let's up level your business. And I know legal, sometimes it's not sexy. It's not cute. It's not the logo and the colors and the website and all the copywriting and the sales copy and all the things that we want to spend tons of money on. But at the end of the day, if you don't have the legal pieces in place, it can really, if the foundation isn't proper, everything can come tumbling down around you. And it doesn't matter how cute your logo is if it's not protected and it ends up on someone else's website.
Ladies, legal is sexy. Thanks, Summit Social. I have a question.
Yes.
It just surfaced because what is the difference between an agreement and a contract, and do you need a notary? Is that a question worth asking? And because I've had some people, not me in particular, challenge other contracts and tell other people that it wasn't notarized. What does that mean, or does that even come into play here? No,
being notarized it's just validation that the person whose signature is there was really there to sign it. That's what a notary is. And I don't use notaries in contracts. I mean, I do, especially a lot of electronic signatures these days. Uh-huh. And if something comes to your email and you sign it, I don't think I really need a notary to say that was you that signed it. And to take it a step further, if you acted in furtherance to that contract, meaning if there was a contract and whether you signed it, whether, if you're later trying to say that it's not enforceable because they can't prove that you signed it. Well, did you do the things that were in there? Did you receive the benefit from that contract that you were supposed to receive? If you acted in furtherance of it, then it's a contract.
Mm-hmm. Brilliant. Thank you. Tamsen, do you have anything to add? No, Joleene, I don't. She answered it brilliantly.
She did? Why I love her.
That's fantastic. So we're talking contracts again for anyone that's just joining us. We're talking speaker contracts. We're talking coaching contracts. Is there anything I should have asked you, a point you want to make, or something that I should have asked you and I didn't? Something you think that's important?
I think people get afraid when they hear the word contract. And what I tell people, it is the most professional, loving, kind thing you can do for your business, because all you're doing is saying, hey, this is what I think I'm agreeing to. This is what I think I'm giving you. Like, it's just putting into writing the conversations you should be having anyhow. So don't let the word contract freak you out. Like, it's the most protective thing you can do. And if you value what you're doing, it's just writing stuff on a piece of paper. I think that's one thing I run into is people, they get all tense and I get it now being on the law side, but really a great contract should never have to be turned on because your expectations are clearly laid out such that if there is a disagreement, you just pull it out and you both go, yeah, that's right. I might not like it, right, but it's right. So that's my goal, is that you have them and you never have to turn them on.
Beautiful. Beautiful.
And I would add that that contracts are essential and they are definitely we want to have them, but I don't want people to think that they don't have the power. If you are presented with one, you don't have to sign it without negotiating, without understanding. And so many people they tense up, or they get afraid, or they think they get a contract and they have to sign that contract. And you don't. You have the right to change things. You have the right to ask questions. You have the right to have your attorney review it. So, I want people to know that you have the power. And I think someone mentioned this earlier, that if you can't come to an agreement on the terms, it's okay to walk away. Mm-hmm. It's okay to say, you know what, then this may not be the speaking engagement for me. This may not be the relationship for me. It's okay to say, that's not quite what I was looking for. So I think that we should, that we may need to go in a different direction. Be okay with that.
That was brilliant. Thank you. I think a lot of people are afraid they're going to lose a major opportunity.
Yeah.
And I think in the end, the important thing is protecting yourself. And again, showing up for your worth, making sure things are very, very clear. So that's brilliant. Question: do you even need an attorney? If two parties sign an agreement without an attorney involved in either side, it's still enforceable, right?
Yes. Oh, yeah. It's enforceable, but the question is whether all the terms that are whether the proper terms are there. So it can be enforceable, but the number one question we talked about earlier is where do you enforce it?
Yes. Yeah.
It's enforceable. You don't need an attorney to have an enforceable contract. A contract could be, I'm going to give you 6 weeks of coaching. You're going to pay me $1,000. Is that our agreement? Yes. But it's all the other stuff. So what happens when you 3 weeks in, you don't want to provide me coaching anymore? Mm-hmm. Or I didn't pay you the $1,000. I paid you $300.
Mm-hmm. Brilliant.
Yeah. And that's when they come to Nakia and I and
that's
say,
when you call me.
Yeah. And what I tell people is take the price that it would have cost you to do it preventatively.
Right.
Now multiply it times 5. That's a good barometer of what it's now going to cost to play cleanup crew. Right. But then they call and say, oh, well, I want to enforce this. And just like Nakia said, we take a look at it and you go, yeah, this is going to be a mess. And that's when people say, oh, legal's so expensive. Oh, legal's not worth it.
Right.
No, legal is worth it. But when it happens after the fact, yeah, I'm not going to tell you to pay me $5,000 when what you're trying to enforce is $500.
Right.
Right. I wouldn't want someone to do that to me, so I'm not going to recommend it for you.
Exactly.
And the result is it turns into, well, law's not even worth it. But it would have been if you had done it about over here.
And I think it's just something that people don't think about. It's not something. It's like I always say this with sales. It's never the other person's fault if they don't understand certain questions they should have asked or certain ways they should have stepped up. It's nobody's fault. It's something that they absolutely have to learn. I don't know who. Looks like someone's calling, but that's okay. We're almost done, and I don't know who that is. I'm sorry. You can post your question if you desire in the comments. But so, and I just want to say one thing, because I had this horrible memory when you were talking. I was foolish enough to allow someone to construct a sales funnel for me, Facebook ad, webinar, the whole 9 yards. It was a DIY. The price was 5 figures, Nakia. And I said, great, I love it. Where's your contract? And he gave me this whole rigmarole about the contract. And I thought, well, he's a well-known person. It's got to be cool. And I'll tell you, it breaks my heart thinking about this, but I screwed myself. The good news is, because he created this sales funnel that didn't function the way that allegedly was supposed to, I asked him for my money back, and he gave it to me. So,
wow.
But I got lucky. I got damn lucky. And I'm going to say damn because I did, because I could have been screwed in that instance. So, it was when I realized, how stupid can I be? I know better than that. Why did I do that? So to this day, I don't make a move until I see it in writing. And when I have a contract, if there's a client that's looking at it and says, I like this, but I don't like this, I do honor it. So I appreciate all of your feedback. Anything else in our last few minutes that we can add or talk about that you think would be valuable to our friends next door here?
Well, I think just to address Summit Social in whether or not to have the question of having an attorney or not, there's always, and you can apply this to anything. There's always a way to do things on your own. And that's you can file your own taxes. You can do your own manicure at home if you want to, or you can pay for, someone who specializes in that to do it. And so, I do think that people can, and I have seen many people who can draft their own contracts. I would not be one to say that you couldn't do it and that it couldn't be done. And you're right in that it's not necessarily perfect. I'm totes about my own pedicures.
High five!
I love it. Definitely. So, it is definitely something that you can possibly do. And I would say if the cost is prohibitive for you, then find the way to do it. Try to do it on your own and then have the attorney review it or consult with you, which is a lot of times is half the price. I personally review contracts for $50 per page and give you my take on, what it is that you should do. So, if there is a way, and you got to think about, if you are selling a $1,000 program or a $2,000 program, what's a couple $100 to make sure that you are protected? Because, the social hit that your brand takes, there's no amount of money you can place on that. And if someone goes on Facebook, because one of the things I always have in my contracts, as we've talked about, is the non-disclosure. You can't badmouth me. You can't go on Facebook and Twitter because this is my brand. And so I need to protect that. So if something goes wrong, we can deal with things confidentially, but you cannot go on Facebook and Instagram and Twitter and Blab and Periscope and everywhere and tarnish my name, because that is damaging to my brand.
Brilliant. Or you could just marry an attorney like I did, and it's all good. So thank you.
Legal work.
Thank you for your insight, ladies. I found this very valuable.
This was fun.
Yeah, it was fun. And I encourage you to share it. I'm sorry we didn't have more people. I really thought this would be something that would be of more value to people. But it was a quiet day, and it's okay. So please share it. And I encourage anybody that's in the room to share it too, because I think this is information that we really, really need to know as coaches and speakers. So thank you, Tamsen. Thank you, Nakia. We'll do it again another time. Have a great day, everybody.
Sounds good.
All right.
Bye.